Thanks very much, John. Joining me now in studio this morning is retired Judge Chris Greenland. Welcome. Thanks for joining us.
Good morning, Devi.
So what was your take of the events as they unfolded in court yesterday?
I was actually in wonderful Botswana yesterday, so I missed it live, but I've been picking it up ever since. And I'm intrigued. I think that's the way I should put it. Very intrigued. But I will say that it didn't surprise me at all. I had predicted on this program a long time ago that this is actually Oscar's defense. I had said that what will happen is that the defense will serve up Oscar in terms of the challenges that he's had in his life, including his physical disability, and couple that to psychological profiling. And they will say that for these reasons, don't judge him as you would judge anybody else. Be slow to judge him. And they will argue that for all those reasons, he is excused. Criminal liability on the basis that his perceptions at the time were not normal, were not the same as other human beings.
So, okay, because the confusion yesterday, we had Ulrich Roo in studio with us, and he was very confused about why is there a psychiatrist now. The psychiatrist should have come a little later on if we got to the point of mitigation of sentence. So are you saying that this is the defense's strategy?
I'm confused about that because, as I've already said, I anticipated or presumed that the evidence that we received yesterday was actually the defense that would be relied on. It's what I would call semi-sane automatism, and we'll talk about that just now. So I was rather bemused that this forensic psychiatrist seems to have only been commissioned 2 weeks ago. So I'm confused about that because, as I've said, I've always thought that this would be Oscar's defense. Strategy, I don't know about strategy, Devi. I am very confused about strategy because other experts on the legal panel have quite correctly voiced their confusion, their bemusement that the defense seems to be jumping from one defense to the other, and they've listed them. And Professor James Grant has very clearly identified at least 4 defenses. Four that have now been proffered, starting with a putative private defense, involuntary action, which is the other one. But anyway, he listed all 4. And I think we can add a 5th now, especially after Wolmerans, and that is obfuscation, because he seemed to adopt the approach that you just take the state evidence, particularly Captain Chris Mangena's evidence, and you throw as much mud at it as you can in the hope of making some progress about discrediting it. So I'm not happy with the defense strategy, if you can call it that, in this case.
Do you think Kerry now is going to bring that application now, today?
I think for the reasons that Professor James Grant listed yesterday. I don't think he has any option, and I don't think the court has any option but to grant it, especially because this witness, the forensic psychiatrist, has said that Oscar is actually a danger to society in certain circumstances. So I think that, my legal colleagues said that as regards this particular aspect, the court has a discretion in terms of the wording of the section. She may, but I think she will be pushed, because of the element of Oscar being a danger to society, to actually grant the application.
What impact would such an application have on this trial so late in the game?
Well, it's going to delay the trial. It's going to, I think, for the reasons that were proffered yesterday very competently by your legal panel, it's going to introduce new aspects. The court will be now in uncharted waters. It was said, I believe with some justification, that Gerinel will score at least an immediate advantage because he'll be able to get evidence before the court, which he would not actually have been able to get. So it'll be a mixed bag for the state. But I mean, for society, what then happens is highly problematical. As was analyzed last night by the legal panel, Oscar could end up in a mental institution for anything, for a period, an indeterminate period. Could be anything as little as 1 year to 25 years or the rest of his life. It's a very problematical situation, in my view.
So, your prediction for today is that Gerinel will make this application.
Yes.
Then what happens? He makes the application. Barry is going to oppose it. Clearly.
I hate
Maybe
to make
not.
that. All things being equal, it looks as if Barry will oppose it. It's difficult.
I'm not
I think he will oppose it, but I wouldn't bet on it.
I think this. Just when you got to a point, I remember Datashi yesterday thinking, okay, now we're in this, we know exactly what's going on, and then you get bam, bam, done. Shocker.
Yes. But I have a more fundamental concern which I'd like to raise with you at some stage about this point that we've reached and about what we've already adverted to. And that is, we are now in a situation where we still don't know really what the defense is.
Surely this is not good for both the defense, both of them, the prosecutions and the defense.
Not good. I think it's not good for anybody. It's not good for the basic test as to whether we are actually seeing justice being done and whether justice actually is being done. I think that this has exposed in a very marvelous way, in a very graphic way, a fundamental problem that we have with our system.
Which is?
Shall we go into it now?
Let's go into it now.
The problem arises because of the blanket right to silence that accrues to an accused person. Ironically, that right accrues in terms of our very, very good Constitution. So it's the Constitution that says that an accused person has a blanket right to silence.
Doesn't have to say anything.
Doesn't have to say anything. Now, what this trial has done is to show how problematical that is. And it raises the question as to whether there is a benefit accruing to society, whether there's a benefit that's accruing to the administration of justice, or whether there's actual prejudice. And I'll stick my neck out because I've thought about this for years. And I've had actual experience of it in two different jurisdictions, in Zimbabwe, where we don't have it, and in South Africa. And I have no doubt whatsoever that incredible prejudice is accruing to South Africa, to our society, because of this, what I call blanket right to silence.
But Oscar said, he testified. He wasn't silent.
No. What has happened here, and we're seeing this, from the time the crime was exposed, from the time that he was arrested, what has happened is that the defense has been allowed to conceal its defense, conceal its position, not explain what needed to be explained. Can I go back one step, Devi, by putting it in the form of a proposition? If a human being, if my car is on video, please produce a video tape of me escaping from the scene of a murder robbery. I'm there, clear on screen. Is there any logical, philosophical reason as to why I should not be immediately required to explain that? In other words, in those circumstances where there's clear evidence of criminal conduct, why should you not be required to explain it immediately? If that was our law, then what would have happened in this trial is that from day one, Oscar would have had to put his defense on the table.
First and foremost.
And we wouldn't have had this pantomime that is playing out here, where Even at this stage, we don't know what the defense is.
Chris, we're going to come back to just that.
Please
Former
do.
Judge Chris Greenland is calling the last couple of days a pantomime at the High Court in Pretoria. But we're going to be back right after this short break.
The truth will prevail in the coming court cases.
We want to know what's happening with the case. That's all we want, the truth.